Now I am going to dictate a legal passage based on English Shorthand Magazine exercise 1 at the rate of 120 words per minute. Let's start. The argument of Sri A.K. Gaur, learned counsel for the petitioners, that the contempt proceedings are not maintainable is therefore without any substance on the facts and disclosed and discussed herein above. In the present case, the judgment in the case of T. Sudhakar Prasad (Supra) as relied upon by the learned counsel for the petitioners, particularly paragraph number 16, in no way comes to the aid of the petitioners so as to invoke the supervisory jurisdiction. Under Article 226 of the Constitution of India, it is no doubt true that the tribunal is amenable to the jurisdiction of this court, but at the same time it is not necessary for this court to interfere with the proceedings unless it is established that the proceedings are coram non judice. In the instant case, there is no material before us so as to demonstrate that the tribunal cannot or could not have issued a notice to the officials of the petitioners to answer the contempt notice. We may again put on record that the manner in which this writ petition has been framed in the official capacity of the officers appears to be only to save them of liabilities which they ought to incur, and is a saving device for reasons best known to them. The aggrieved persons would be the officials who had been impleaded by name in the contempt application and not the officers in official capacity. Para. There is yet another aspect, namely that against the punishment by the tribunal upon conviction and appeal lies directly to the Supreme Court, and in such circumstances to certain a writ petition would be not in conformity with the scheme of the Contempt of Courts Act 1971, read with Section 17 of the Administrative Tribunals Act 1985, unless the proceedings are patently without jurisdiction or are otherwise ultravious the Constitution or the provisions of any act. A writ petition may lie against an order of the tribunal refusing to issue notices for contempt as held by the apex court in the case of Sujitendranath Singh Roy versus State of West Bengal and others, 2015 12 SCC 514. The preliminary objection raised by the respondent number 1 as incorporated in the interim order dated 16th December 2010 had not been answered in the said order, nor have we been able to find any argument on behalf of the petitioners that may dislodge the preliminary objection raised by the respondent. Further, as observed herein above, once the tribunal itself had issued directions on 22/01/2008 for ensuring the orders for compliance in the contempt to jurisdiction and leaving it open to the respondent number 1 to file a fresh contempt application in the event of non-compliance by the judgment dated 22nd January 2008, we see no reason over and above the reasons indicated herein above as to why the respondent number 1 could not have filed the contempt application when he alleges the order dated 24th February 2010 to be a contemptuous order which is yet to be examined in the proceedings before the tribunal. Stop. Thank you.